SQE preparation criminal practice classification of offences by street lawyer, helping you to pass first time. What is covered in this class? This class serves as an important introduction to the topic of classification of offences and features throughout the SQE1 preparation course because the SRA FLK assessment to criminal law and practice states this: first hearings before the magistrate's court, classification of offences. So what I want to do in this class is to outline the terminology to classify offences, and I want to introduce you to and have an appreciation of this topic, classification of offences, when it comes to the detention clock at the police station, that is the maximum time a suspect can be held at the police station for, and allocation of business at the magistrate's court, that is the progress of a criminal case and where it is eventually going to be heard for adult defendant cases. There are separate and more detailed classes on the detention clock and the allocation of business between the magistrate's court and the Crown Court, so please watch those classes. SQE1 exam tip. Questions where classification of offences feature may centre on the power of custody officers to extend the detention time of a suspect who is arrested for a particular offence and which court the defendant's case will be heard or may be heard, that is at the magistrate's court or the Crown Court, depending on the offence the defendant faces. Knowing how criminal offences are classified is key to answering these questions correctly. Now look at test your knowledge questions 1 and questions 2. Question 1 is: the suspect Tony is arrested for murder and asks the custody officer, what is the maximum time you can keep me at the police station before charge? The custody officer replies, depending on satisfying the criteria, the police can keep you for a maximum 96 hours. Is the answer given by the custody officer true or false? An alternative question is: what if Tony was arrested for simple assault? Can the police detain Tony without charge for 96 hours? Question 2. Tony is charged with shoplifting of over £300 worth of vodka and intends to plead not guilty. The defence solicitor tells Tony the magistrate's court have power to retain jurisdiction and you, Tony, will have no choice but for your case to be dealt with at the magistrate's court. Is the answer given by the defence solicitor true or false? At the end of class, you'll see what the answer is. So let's get into class. Question: what are the 3 ways criminal offences can be classified into? There are 3 ways offences can be classified. 1. Summary only offences. 2. Either way offences, and 3. Indictable only offences. Question: what are summary only offences? Generally, summary only offences can only be dealt with at the magistrate's court. Subject to limited exceptions, this means they can only be tried and sentenced at the magistrate's court. Summary only offences are less serious offences and carry lighter sentences than either way and indictable only offences. Example of summary only offences include simple assault and battery. Question: when can a summary only offence be heard at the Crown Court? Summary only offences can still be heard and dealt with at the Crown Court when a defendant is charged with other offences such as a serious high value theft, either way offence, and a robbery, an indictable only offence, which would go to the Crown Court for trial and or sentence. What are either way offences? Either way offences are offences which can be heard and dealt with at either the magistrate's court or the Crown Court. This depends on a number of factors, including how serious the offence in question is, the sentencing powers of the magistrate's court, the defendant's wishes, depending whether they are given a choice, whether they would like their case to be tried at the magistrate's court or the Crown Court. Example of either way offences include a Section 20 wounding inflicting GBH or a Section 47 ABH actual bodily harm, criminal damage valued at £5,000 or more, or damage caused by fire, that is arson. Question: what are indictable only offences? Indictable only offences can only be heard and dealt with at the Crown Court. Indictable only offences are the most serious offences, and examples of indictable only offences include murder and robbery. Now look at this test your knowledge question and research from your books. Which of the following offences are summary only, either way, or indictable only offences? And pay particular attention to those offences in red because they feature often in single best answer questions. And pause the video and check the next slide for the answers. Now look at the answers to the test your knowledge and pause this video to see and check whether your answers are correct. And pay particular attention to the ones in red because these feature quite commonly in single best answer questions. Now let's return to those test your knowledge questions at the beginning of class. Question 1. The suspect Tony is arrested for murder and asks the custody officer, what is the maximum time you can keep me at the police station before charge? The custody officer replies, depending on satisfying the criteria, the police can keep you for a maximum 96 hours. Is the answer given by the custody officer true or false? Answer: true. Subject to the criteria made out. This is because murder is an indictable only offence. This point is further explored in the class on the detention clock. Alternative question: what if Tony was arrested for simple assault? Can the police detain Tony without charge for 96 hours? Answer: false. This is because simple assault is a summary only offence. The maximum period a suspect can be detained before charge for a summary only offence is 24 hours. Question 2. Tony is charged with shoplifting of over £300 worth of vodka and intends to plead not guilty. The defence solicitor tells Tony, the magistrate's court have power to retain jurisdiction and you, Tony, will have no choice but for your case to be dealt with at the magistrate's court. Is the answer given by the defence solicitor true or false? Answer: false. This charge would amount to an either way offence, and if Tony pleads not guilty, Tony will have a choice whether to have a magistrate's trial or a Crown Court trial. Remember, watch all the videos in the SQE Prep Criminal Practice series. Understand the functioning legal knowledge being examined by reading the SRA website for yourself. Revise from a good SQE book. Attend and participate in class. Prepare Q&A flashcards. Practice as many SBAQs as possible. Subscribe to Community Legal Education on YouTube and put your notification on so you don't miss out on more SQE prep videos. Hope you found this class useful. See you in the next class and thank you for watching.